Hello everyone and welcome to today's Mondat webinar in association with Greenberg Traurig, who will be exploring the ever-evolving landscape of class action litigation, providing an in-depth discussion of the latest trends and future outlook for class action lawsuits. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. But before I hand over to Robert and our panel to begin, a housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page. The panel will endeavour to answer as many questions as possible during the Q&A session, but please do reach out after the webinar for any additional information you may require. It's now my pleasure to hand you over to Robert to begin. Thank you.
Great. Good morning, good afternoon, good evening to everybody. Thank you for joining us here. We've got a great program, hopefully that is a value add for everybody. We're going to walk through 4 areas of class action practice, particularly in the States, but I think is applicable elsewhere as well. The first one is going to focus on privacy litigation, particularly some of the new claims and theories that we are seeing. The second panel is going to discuss developments in financial services class actions. Then we're going to have a great discussion, in-depth discussion about the latest trends that we're seeing in the area of cosmetics and personal care products and how that industry is being affected by class actions. And then we're going to close by talking about mass arbitrations, which is the plaintiff's class action bar's latest sort of maneuver to continue to pursue these types of claims. So we're going to start with, we've got a great panel. I'll kind of introduce them as we come up here, but just real quickly. So Rebecca Guyon will start. She is our privacy expert, and she'll kind of cover that section. And then Jonathan Clayton and Sylvia Simpson, John from Chicago and Sylvia from New York, will talk about financial services. Nilda Isidro, who also in New York, will cover the issues relating to cosmetics, personal care products, and Mike McCarthy in Los Angeles will talk about mass arbitrations. So let's kick this off by starting with privacy. So Rebecca, why don't you go ahead and take this away, but sort of what are the key things that you're planning to talk about within privacy?
Yeah, so I'm going to focus on the trends that we've seen in the last year in data privacy litigation and where we think this is going coming into 2024. So I'll start centering us with a little bit of history on the key decisions that have kicked off the current wave of data privacy litigation that we're in right now. Then we'll talk about what's happened in that wave and whether that wave is over or not. The new theories, which are generally focused on a form of advertising technology called pixels, but other forms of advertising technology are getting swept into this as well. Briefly on the Video Privacy Protection Act, there was a spike in cases and then probably an ebb in cases. And then what I think you might see looking into 2024.
That's great. Rebecca, so to start off here with wiretapping and sort of this initial, or the AdTech litigation, what is that all about?
Sure, yeah, so depending on how you count the waves, we're in a third or fourth wave of wiretapping litigation nationwide that started really in 2020 and has gone up and down in terms of wins and successes since then. So the reason we see so many wiretapping cases right now, and that actually, as I was putting these slides together, it's on a later slide, but there have been more than 600 putative class action wiretapping cases filed since late 2022 through 2023. So it's a huge area of interest for the plaintiff's bar. I would say no company is exempt here because the form, they are all website-based claims. Everybody has a website, and they are based on advertising technology that probably everybody uses and probably your legal team doesn't know in-house that you're using them. So why wiretapping? Biggest reason is there's statutory damages available under a number of states. In California, it can be up to $5,000 per violation. The basic theory is that there was a recording or monitoring of the contents of a communication without whatever form of consent is required. And these are predominantly state law claims. There's a federal wiretap act, but because it is one party consent, it's a borderline frivolous claim for most AdTech suits. I think the other reason, I'll just say briefly, you see so many wiretapping based claims is everybody's focused on CPRA, Connecticut, Colorado, all of your privacy regulatory regimes at the state level. And the bad news I have to tell you is you can do everything perfect from a regulatory compliance standpoint, and that's great. You'll avoid the Attorney General of your state, but you will not avoid the plaintiff's class action bar, who is focused on the very expansive definitions of contents that can get swept into a wiretapping claim. So it's not 100% overlap between what you do for regulatory compliance and what you do to avoid litigation.
And Rebecca, what states do we need to be worried about with this kind of a theory?
Yeah, so there are 15 states that have a form of two-party consent for wiretapping, and just, you know, for everybody who's on this call, two-party consent requires at some level that both people who are on the call agree that it can be recorded and or listened to by a third party. I say a form of two-party consent because really the way these statutes are written, it's not straight two-party consent. For example, most people don't realize in California, for non-confidential communication, any party can record it without telling the other party. And then after it's recorded, you can do whatever you want with it. Illinois, not really two-party consent. The jurisprudence has kind of chipped away at that so that it's essentially a one-party consent in most instances. We can go ahead to the next slide and I'll talk some more about where we have, why these states are of interest. So like I said, depending on how you count waves of data privacy litigation, we are in either our third or fourth wave of website wiretapping litigation since 2020. There are 3 decisions that have really brought us to where we are. The first goes back to the summer of 2020. It's in re Facebook internet tracking litigation. As I mentioned on the slide, it sounds kind of technical, but essentially what the Ninth Circuit held in the Facebook decision was, I mentioned a moment ago that California, even though we're two-party consent, a party can record a communication as long as they are actually receiving it directly. For in re Facebook, a lot of advertising technology could avoid wiretapping liability because the way AdTech works on a website is it directly receives whatever it is that it's allegedly recording. So if we're talking about, you know, cookies, a cookie on your website directly receives whatever goes into the browser. And there is no subsequent save it, send it on that, you know, could really remove you from the party exception to liability. And that's both in California and under the Federal Wiretap Act statute. Even though Federal Wiretap Act is one party consent, there's this additional exception really because it's written for law enforcement to have, you know, bright line rules there. So in the in re Facebook case, which is really what kicked all of this off a few years ago, the Ninth Circuit said where the in re Facebook case is about pixels, which I'll come back to in a second, but it's really the latest form of advertising technology. The Ninth Circuit said where your ad tech is getting the data simultaneously, as you know, as it is a direct recipient, no question, it is a direct recipient of whatever is going on the web page. But Facebook privacy policy, Facebook was managing the pixels, or Facebook operated the pixels, I should say. Facebook's privacy policy said, after you log out of Facebook everywhere, all your devices, we won't use our pixels to follow you anymore. However, in this case, it was alleged that they did follow people after they had logged out of all of their devices with pixels. So the Ninth Circuit said where there's that allegation of deception, even though you have a direct recipient under a very well, going back 30 years, established exception to wiretapping liability at the state and federal level, you can't profit from it because there's a potential deception there. And deception is something I think we should keep in mind. I'm going to preview that to what we're looking forward to 2024. So yeah, we can go ahead to the next slide. That was 2020.
Rebecca, one thing that always confused me about some of this stuff is like, how do you wiretap yourself?
Yes.
And how does that kind of play into what's going on here?
Right. So how do you wiretap yourself? Well, I guess probably the purest, the way I would think about that is, like I said, in the federal wiretapping statute, it's a one-party consent statute. So in theory, as long as I know I have this AdTech on my website and I own the website, any one-party consent should be just null and void because I have agreed to it. The idea is that even when there is this kind of deception going on, you are still facing potential liability. Obviously, you're not going to sue yourself. So two other decisions, 2022, that led to where we have been in 2023. POPA versus Harriet Carter Gifts. This was under Pennsylvania's wiretapping statute. The Third Circuit held, and I would say it was a misapplication of Pennsylvania law, but the Third Circuit held that the party exception to liability, similar to under California law, under the Pennsylvania statute, only applies to law enforcement. So if you have a civil claim, doesn't matter, you do not have any direct recipient exception to liability. The Javier case, Ninth Circuit from 2020 summer, held that even where you have express consent, so even if you have some on your website an express disclosure that someone has to agree to, let's call it a cookie banner, let's call it just this call may be recorded or monitored in a chat feature, all of those that we've seen in the past. But if the recording or monitoring commenced before that express consent was obtained, you still have liability. So in other words, even where there is extremely express consent, it cannot apply retroactively. That's relevant because AdTech, all the stuff we're talking about, it drops as soon as you go to a web page in most instances. So that's where you get liability. As I said, it led to over 600 wiretapping website-based claims or putative class actions filed nationwide after the Popa and Javier decision. Predominantly, we're seeing the plaintiffs bar attempting to test these in jurisdictions where the law has not really been tested yet. Pennsylvania is a obvious forum for that, but seen many suits in Maryland as well as Missouri, some in New Jersey, the other two-party consent states I mentioned a moment ago. Initially, these suits were all focused on session replay. I'll just say briefly what session replay is. Not exactly AdTech, but it's an analytics tool that can allow you to determine what works well, what doesn't work well on your website. Really, it's designed to find like angry clicks or like failed mouse or failed links to improve the user experience. We're seeing less session replay litigation filed, but it dovetails into what I think we're going to see going into 2024, kind of on the analytics front. So all of that in the wiretapping putative data privacy class action context has led to mixed results. Honestly, I'm a California litigator, and I've been pleasantly surprised that in California, we've generally had good success on these claims showing that either the elements don't apply or that Article 3 standing in federal court just isn't present. Some plaintiffs have pivoted to bringing the cases in state court instead, but even there's been not a lot of success. I'm highlighting only two decisions. There have been hundreds in this space, but I think these two decisions show kind of the spectrum. Cook versus GameStop in Pennsylvania. It's on appeal. It'll be very interesting to see what the outcome is there because it directly challenges the POPA decision. But a district court held that mostly under Iqbal and Twombly principles, just alleging the use of AdTech, in that case it was session replay, is not going to get you across the line. That you're not alleging the content of a communication. You're not alleging that there was a lack of consent. And the court also found there was no standing in the Cook v. GameStop decision. Revich v. New Moose Jaw, it's an older decision, but I flag it because I see the plaintiffs bar waving it around all the time. That decision, district court, but the court said essentially every interaction on your website is a communication. And that matters because these are all, the limited scope of these claims is applying to communications. And most of what AdTech and analytics picks up is not communications, at least I would argue. Showing you if a link works or doesn't, I would say that's not a communication. What web page you're looking at, not a communication. So what we've seen is with session replay on the decline, a pivot to, and this is what the plaintiffs bar always does, new forms of technology that could be potentially encompassed by wiretapping statutes. Pixels, I mentioned, they were in the Facebook case. They are sort of a next-gen cookie, but they are a piece of AdTech that it doesn't reside in your browser like a cookie, but it allows you to know when something is happening on your website. For example, who's clicking on what? Did they look at this page view? Pivot to financial and health information. I think, that will preview some of our later sessions on a theory that is more, these are all privacy-based claims. The theory is when your AdTech is used to acquire financial or health information, you're closer to the serious invasion of privacy that can support a common law claim. And expanding to other ubiquitous forms of AdTech, lately I've seen a lot of suits around Google Analytics, which is not session replay, but it is extremely valuable. It tells you how your website's working, from where, and who's using it, and how and why.
So Rebecca, I want to sort of jump ahead if we can.
Yeah.
Sure we stay on track. We've got some great slides in here on the Video Privacy Protection Act, as well as a host of decisions that are all worth reading here. I wanted to give you a chance, though, to make sure to focus on kind of what is coming in 2024. So if you can kind of sum up and focus on what the outlook is.
Absolutely, yeah. So, and that makes sense because I think VPPA is really on the downturn, which is good news for everybody who's on this call. So three trends, I think, like I mentioned, we're going to continue to see wiretapping litigation being tested as applied to new technologies. I can't tell you how many clients I've spoken with who do not know that they have pixels on their website. They do not know what their Google Analytics is doing, and they have not had any interaction with their marketing team who's setting all of these in place until they get a wiretapping suit or, more recently, demand letter, and then they're doing a deep dive. So we will continue to see those. I think I'll address mass arbitration just briefly. I know Mike's going to go into that in more detail, but with the lack of success in courts, the plaintiff's bar has really taken these decisions to a mass arbitration threat. And that's where they wave around the theory that any website interaction is a communication. And then we have seen literally 20,000 individual arbitrations being filed based on wiretapping theory. And there, the main difference is you don't have Article 3 standing, which has been a key point of success for defendants in federal court. Also, I think we'll see deceptive cookie banner theories. As I mentioned at the outset, these claims all have, they're all consent-based claims. So where there is deception, you always have a problem. This is just one example, food for thought. I have seen increasingly suits claiming that even though you have a cookie banner, and this is where your regulatory compliance comes into focus, your cookie banner didn't really tell me what you were doing. And so I didn't consent. So here's your putative class action or mass arbitration. I think that's what we're going to see looking into 2024.
Great, Rebecca, thank you. I want to turn so John and Sylvia up next in terms of discussing financial services class actions. John is a shareholder partner in our Chicago office and does a ton of work for banks and various financial institutions. Sylvia, again, is a partner in our New York office, and again, really focuses and specializes on financial services class actions. So, guys, with that, why don't you sort of give us the overview and take it away?
Yeah, hey, thanks, Rob. I appreciate that intro, and thanks to all who are here listening in. You know, in the brief time we're allotted, we're going to try to touch on some key topics that we're seeing that impact the cross-section of the financial services litigation space and, you know, the class action, mass action practice. And so I'll turn it over to my partner, Sylvia, who's part of our financial services and class action team. I would just note, you know, there really is a great deal of overlap even with this topic and the topics our colleagues are talking about here today. You know, for instance, Rebecca, who just talked about privacy, she and I have been working on, you know, wiretapping claims against a number of banks, dealing with voice verification. You know, when you call in to verify that you are who you say you are, enterprising people are still suing banks and financial institutions for taking the time to make sure that there's not a fraudster calling in. And, you know, Mike McCarthy will be talking about mass arbitrations, and that's something that financial institutions are seeing more and more of, you know, given the effectiveness of motions to compel arbitration and enforcement of class action waivers. So there really is a cross section running through all of this that we hope you find useful. So with that, I'll turn it over to Sylvia.
Thanks, John. So the first thing we're going to talk about is standing. And as everyone knows, the Supreme Court ruled in the TransUnion case recently, no standing, right? But it did not address whether every class member has to show standing before certifying a Rule 23b3 damages class. So here we have a little screenshot showing the relevant footnote here says we do not here address the distinct question of whether every class member must demonstrate standing before a court certifies a class. So, you know, what's happened since then, you know, defendants have argued the plaintiffs have to show absent class members have Article 3 standing, but courts have generally rejected that argument and adhered to kind of the pre-TransUnion case law that the named plaintiff or plaintiffs have to establish standing at the class certification stage, but not necessarily every absent class member. However, you know, where we are right now is courts are taking a closer look at the absent class member Article 3 standing issue when assessing whether or not plaintiffs who are seeking to certify their class have in fact satisfied the various requirements for them to get class certification, including predominance. And we've seen a number of instances where courts have found that if you need mini trials to identify and separate uninjured class members, then individual inquiries on standing may predominate over common questions, and necessarily you can't establish predominance. So here we have an example shortly after TransUnion out of the Ninth Circuit that vacated approval of a settlement class where the class may have included members who lacked Article 3 standing. And here, the court noted that there's evidence in the record demonstrating that there were class members who had not suffered an injury through Morgan Stanley's AFG program, and that the district court didn't make that factual finding that every class member suffered some injury. And we've seen a number of instances where this has happened across the country in various circuits, but courts are looking, even the Ninth Circuit is looking very closely at whether or not standing is going to defeat class certification because they won't be able to establish predominance. So this is something that as defense practitioners, we want to look at very closely when we are challenging a class certification request. So turning to the next slide, Rob, another recent standing decision that we should all be looking very closely at out of the Second Circuit this time is just a couple months old, is the Bonac versus Marsh and McLennan case right here. And in this case, the court found that a risk of future harm associated with personal identifying information disclosure out of a data breach when coupled with other separate harms, is going to be enough to satisfy the concrete harm, imminent harm requirement to establish standing. And in this case, this was a former employee of a company. The company had a data breach. Among other things, Social Security number was released to the public. And the Second Circuit found that the district court erred when finding that that was not enough to satisfy the concrete harm requirement, and looked to not only the fact that the data breach itself and the disclosure itself was a concrete harm, but focused on that there were other separate and concrete harms that the plaintiff had pointed to. Out-of-pocket expenses, lost time, other opportunity costs that they said that they had associated with mitigating that data breach consequence. And the court also reiterated that as far as evaluating whether or not a harm is imminent, the Second Circuit is still going to look to the McMorris decision, which came out pre-TransUnion, in evaluating imminence. And so this is an important decision, I think, that particularly in evaluating whether or not something satisfies the concrete harm requirement, particularly when it deals with data breaches or a personal identifying information like a Social Security number. This case, I think, is going to really be important moving forward in that context. Moving to the next slide, another important issue I think that we're all facing, like John said, across all industries, but certainly in the financial services space, is dealing with arbitration. And as we all know, account agreements associated with financial institutions often have arbitration clauses. And the Supreme Court's recent decision in Coinbase, I think, is particularly important when thinking about the question of arbitrability and whether or not a stay is required. In this particular case, Coinbase filed an interlocutory appeal in connection with the denial of a motion to compel arbitration. The Ninth Circuit also declined to stay the case, and it went to the Supreme Court. And the Supreme Court found that because the question on appeal is whether the case belongs in arbitration or belongs in court, the entire case is essentially involved in the appeal, and a stay is appropriate. We have a little screenshot here showing that was common practice across the country, and that common practice reflects common sense. This is a pretty important decision on the stay component, and certainly is also something that defendants can rely upon to say that stays should be appropriate when you are filing a motion to compel in the district court as well. Next slide, Rob. Speaking about motions to compel arbitration, we've been seeing a number, previous slide, sorry. We've been seeing a number of grants of motions to compel arbitration for financial institutions across the country. Like I said, financial institutions are going to invoke their arbitration provisions, particularly the class action waiver components, when a class action is filed. We've seen district courts ranging from New York to California to Colorado, granting motions to compel arbitration for banks and other financial institutions on that basis. While some plaintiffs seek to evade arbitration by arguing that the underlying agreement is invalid or unconscionable, in light of California's McGill doctrine, they point to the fact that they say that the agreement will prevent them from obtaining injunctive relief. A number of courts have declined to invalidate agreements where really the true request the plaintiffs are seeking are damages or something else, right? It's not relief for the public at large. This is, conclusory, unsupported reference to public injunctive relief into a complaint is just not going to get you there, and it's not going to have a court invalidate a decision, an agreement under the McGill doctrine. So we've been seeing a number of cases reaching that. Here we've referenced a case out of California itself from July of this year, but we've been seeing decisions like this across the country where courts are saying, bald unsupported references just not going to be enough, and granting motions to compel arbitration for financial institutions. Now, turning to denials, the limited number of courts have declined to enforce arbitration in financial institution agreements, but these are relatively discrete cases. We have, two examples here. One is where service members are the ones who are the named plaintiffs. And this case out of the Eastern District of North Carolina noted that service members can bring and participate in class actions, notwithstanding the fact that there might be an account agreement in place following the Service Members Civil Relief Act. And then the other exception, which is the first bullet here, is if the original agreement, account agreement, did not include an arbitration provision, but stated the terms may be amended over time, notifying that there's been an update to the terms is not going to be enough to provide an express notice of an opt-out right. So if you have an account statement that says, please note that we've amended our terms of service, that won't be enough because it's not notifying the plaintiff of the fact that, going back to the account agreement, now there is an arbitration provision that they need to contend with. But again, this is only where the original agreement did not include an arbitration provision in it. So again, relatively discreet, but wanted to point that out. And as far as turning to other pretty recent important decisions in the arbitration space is the Edmondson case versus Klarna out of the Second Circuit. This is pretty important with respect to web-based contracts. So a number of financial institutions or financial service offerings will have web-based contracts, and access, for example, to that agreement will be provided by hyperlink, for example, and then there needs to be a click of a button or a checkbox where the user or customer needs to manifest their assent to that agreement before they can proceed and actually take it service offerings. This decision kind of reiterates some of the prior decisions, but we haven't seen a decision out of the Second Circuit regarding these issues in a couple of years. And this decision kind of goes through what a reasonably prudent internet or smartphone user is going to be thinking, and kind of who that reasonably prudent user would be, and makes clear that it does require some familiarity with how to navigate to a website or download an app. So for example, if you have something that's in blue and it's underlined, that's a hyperlink. You can click on it and that's going to bring you to the underlying agreement. So pretty helpful. The Meyer decision, which it refers to, I believe it's from 2017, so some time ago. But again, kind of reiterate the same principles as far as a reasonably prudent user. And then the Second Circuit goes on to talk about some other things that are pretty important when looking to the actual interface by which the financial services company or any company is putting the arbitration provision to face the customer or the user, and speaks at length about the need for an uncluttered interface, so that is visually present to the user, and also if it's temporally and spatially coupled with the mechanism for manifesting assent. So if the access to the agreement is very close and next to where the user has to manifest their assent by clicking that box or clicking that button, that's sufficient to qualify as reasonably conspicuous notice as a matter of law. And then also goes on to note, which is pretty important, an explicit I agree is not necessary, and you can look to other factors, including that the interface clearly warned the user that taking that action will constitute assent, such as creating an account, and then again, the timing and location of being presented with the terms. And the Second Circuit also highlighted that there's no requirement for a company to explicitly advise the user, hey, clicking means that you're manifesting assent, right? The interface only needs to make clear, again, what a reasonably prudent user would need to know. So it's some helpful case line there, certainly from the defendant's perspective. This case reversed the arbitration denial and said that the interface for Klarna was sufficient.
Yeah, Sylvia, thank you. John, I want to try to keep us on track here. So we've got some information on Ponzi schemes and cases. Do you guys, John, Sylvia, do you want to try to summarize those, and then we'll flip it over to Nilda?
Yeah, I'll give a quick overview. Thanks. So we deal with a lot of cases in our financial services practice dealing with Ponzi schemes and other frauds, and just a couple high-level things. There's been a very large surge in such cases just in the last 2 years. The amount of Ponzi schemes uncovered in 2022 was up 70% over 2021, and at least as of now accounted for over $5 billion in investor losses. And that's just the ones they've uncovered, and we expect the trend to be that way for 2023 as well. And interestingly enough, over, or maybe also not unsurprisingly, at least a quarter of those involve some sort of crypto investment vehicle. And so there's a lot of this happening. It's always there. And financial services clients from major banks down to fintechs are often targets when the dust clears and people are sorting through the rubble, because they're the ones with pockets that still have money, and money's usually gone, right? And so just a couple high level things to think of. As you go through your defense arsenal when you're dealing with these things. It's always key to see who's suing you. If there's a receiver or trustee trying to sue on behalf of a group of investors, there are arguments to be made that they don't have proper standing to do so, because if they are in fact appointed to oversee and manage the assets of an entity that was the vehicle of the fraud, they take with all of the defenses, but also all of the negatives that entity had. There's some good case law developing. The 11th Circuit is best on it, that say a receiver or trustee in that situation, whether or not it's unclean hands or whatever the idea is, they can't sue because they actually benefited from and were part of the scheme. So that's a key thing to look at. The other thing, if you're not in that situation, and obviously sometimes these are individual cases, but there are an increase of class cases where you have a pool of investors that have been injured. The allegations that focus on should have known, i.e., the bank or the financial institution that banked a fraudster, that they should have known of the fraud. The case law is generally pretty good. That should have known isn't good enough. There has to be actual knowledge of a fraud in order for there to be secondary liability. The key here is that intelligent plaintiffs' counsel are trying to expand that to encompass things like a willful blindness type theory, that people turn a blind eye to things to make profits. Or another one that we've seen had to deal with is collective knowledge, the idea that you should be able to aggregate the little bits and pieces of knowledge that, say, a branch teller had about somebody's practices, along with, what an inside fraud or AML investigator knew. So while the argument would go that, well, not all the knowledge was in one person's head, the bank as an entity had full knowledge. Rob, you can go to the next slide, please. Yeah. In an effort to keep us on track, I won't go through a discussion of these cases, but these are some good cases that talk about these things, and talk about and put out, on all of those topics, especially focusing on the really fine point about what type of allegations or proof are sufficient to push it over from a should have known type constructive knowledge to the actual knowledge that's required, for an aiding and abetting or secondary liability claim. Rob, you can go to the next one because I'll move along, because I know we got to have time for other folks. I'll talk quickly here because we're seeing an uptick in these types of cases as well. And a lot of this stems from the CFPB's regulatory move a couple years ago to give guidance on what was an unauthorized transaction out of someone's account, given the massive increase of fraud schemes where, unfortunately people are just being duped, to send things over Zelle or to send ACH payments or even online wires in response to people posing, as legitimate, bank employees, utility employees, or stepping in as, closing employees when people are unfortunately wiring down payments for houses. A lot of these cases are individual, but where you have something like Zelle, for instance, or another payment app, which is interesting because the CFPB just announced yesterday that they're intending to expand their oversight over payment apps to Google and Apple and Cash App, non-bank entities that are processing things. People have tried to make class claims based on the idea that there's a uniform policy impacting customers, where banks are not living up to their contract terms about, fraud protection and reimbursement obligations and such. And, there's a lot of case law developing on this, some good for defendants, some not. The Navy Federal Credit Union, their case, essentially was a home run win because, the court said there's no violation of any Deceptive Practices Act. There's no violation of the contract. Nothing that the bank said was wrong. The customer just was scammed, and unfortunately pressed the button themselves and sent the money to the fraudster, and that they didn't have any recompense. So, I'll wrap up there. There's always going to be new theories. There's always going to be, like Rebecca mentioned, people following in the wake of the regulators to try to come up with new class action theories, and as we follow along with the CFPB or even the OCC with some increased obligations as to knowing your customer and anti-money laundering requirements, that there'll be new theories in the coming months and years to address. So thanks for the time, and we'll pass it along to Nilda.
Great. Yeah, and so Nilda, will transition directly to you. Nilda Cedro is a real expert in this area and is in our New York office. And this is an area that's just exploding, at least in my view, with new theories and cases. So Nilda, why don't you take it away?
Thank you, Rob. Yes, absolutely. This is an area that has been seeing a lot of activity. And so given the time constraints, we're only going to go over a selection of that activity. It's not going to be completely comprehensive. So with that disclaimer, we'll jump right into it with the hair relaxer litigation, which is one of the newer MDLs to be created in this space. And this litigation was kicked off by an October 2022 article in the Journal of the National Cancer Institute, which published findings suggesting a link between use of hair straightening products, a variety of hair straightening products, and uterine cancer. The study was not definitive. It acknowledged itself that additional research was needed. The study also did not identify specific products or even a specific category of products. It involved multiple different types of products that are used in hair straightening. But nevertheless, lawsuits ensued. There is a new study that was just recently made public last month that focused primarily on postmenopausal Black women and a link with uterine cancer and use of hair straighteners. But again, this research is very much in its infancy and is not necessarily robust at this point. That has not stopped the litigation, of course. And so while most of the cases involved in this litigation involve claims of personal injury, so folks actually claiming that they developed cancer, it has not been limited to uterine cancer. The claims have involved other types of cancer, breast cancer, cervical cancer. They've also involved claims like miscarriage or preterm births. And so, but even though most of the cases have been personal injury, there have been certain cases that have been putative class actions. And those cases have sought class actions for consumer fraud, breach of warranty, and also for medical monitoring for development of these illnesses. The MDL was created in February of this year, and there is currently an omnibus motion to dismiss that is pending. The motion has a number of different bases, but two of the key ones are significant pleading deficiencies. So as I mentioned, the study did not identify particular products. It also did not identify particular ingredients that the researchers thought were linked, were sort of causing this increased incidence of uterine cancer that they observed. And so defendants claim that there's no basis to assert a defect as to specific products. Many of the plaintiffs haven't even identified specific products. They've generally identified product lines, not even a particular product within a brand. They have not identified particular ingredients that they think are associated with this. And so defendants argue that this does not sufficiently state a claim for product defect for these personal injury cases. There also, for the non-product liability cases, the main basis is preemption. So to the extent plaintiffs are, for example, claiming consumer fraud because of, in some instances, they're claiming there should have been additional disclosure on the labeling or, particular highlighting of certain ingredients. And defendants argue that these claims are preempted by federal law. So that motion is pending, and we'll see what the outcome is in the coming months. With that, we'll move on to another litigation involving hair care products, which is benzene and dry shampoo. And similar to the hair relaxer litigation, this sort of started with laboratory findings, in this case, findings by Valisure, which we'll talk about a little bit more in a moment, as opposed to published literature. But in October of 2022, Valisure issued a citizen's petition to the FDA claiming that it had found benzene in multiple dry shampoo products. The petition requested that the FDA commissioner take a number of actions, including, publishing guidance, providing information to the public, and requesting a recall. Next slide. It also requested that additional guidance be provided and that additional rules be promulgated. You can move on to the next one.
Valisure. Tell us about Valisure.
So Valisure claims to be a laboratory whose mission is to help ensure the safety, quality, and consistency of medications and supplements. It claims to apply proprietary analytical technologies that it uses in addition to FDA standard methods. And I flag that in addition to FDA standard methods. Those of us in the class action space have come to know Valisure as a frequent player and a frequent inciter of class action litigation. If we can move to the next slide. We will see that Valisure has been involved in spurring recalls and class action litigations across a number of types of products in the cosmetic and personal care industry. Hand sanitizers, sunscreens, body spray products, all of those involved alleged findings of benzene from Valisure. And their activity has not been limited to the cosmetic and personal care industry. They've, of course, been involved in spurring recalls and class action litigation in prescription pharmaceuticals, blood pressure medication, diabetes medication, as well as over-the-counter and prescription reflux disease medications. So they've definitely been a frequent player, and that was, that has been the case here as well in the benzene litigation. Before we move on to some troubles that Valisure has recently been facing, we'll talk a little bit more about what's been going on in this benzene and dry shampoo litigation. These have largely not been coordinated. They're still pending in different courts, different independent putative class actions. Most of them have motions to dismiss currently pending. The specific grounds have varied, but a common theme that it's emerging is lack of Article 3 standing. Specifically, plaintiffs have failed to allege that they purchased products that actually did contain benzene. So when Valisure did its testing, they did not find benzene in every single sample that they tested. So plaintiffs have a problem in terms of establishing that the particular products that they purchased and used contained benzene. And that may prevent them from being able to establish Article 3 standing. Another common theme that has emerged in these motions to dismiss is primary jurisdiction, cosmetics being FDA regulated products, FDA being aware of this issue, Valisure itself having asked FDA to sort of step in and issue guidance on this and take different actions on this. And so to the extent that FDA has not done that, it is not for the courts to sort of step into FDA's role on that. This should really continue to be carved out for FDA, and primary jurisdiction should apply. Again, these motions largely remain pending, and we'll see in the coming months how they develop. So as I mentioned, Valisure has been experiencing some troubles, which may or may not cause it to be less of a prominent player in class action litigation going forward. That remains to be seen. But FDA conducted an inspection of Valisure in 2021. At the very end of last year, issued an untitled letter to Valisure, citing a number of failures. Failure to make certain investigations, failure to determine certain illegitimate products, failure to file annual reports with FDA as they're required to do. And so things have been a little bit more quiet with Valisure since then. And it remains to be seen how that will continue to unfold. The analytical methods in particular were cited, and that is something that we're starting to see coming up in motions to dismiss, right? So not only did Valisure not find benzene in every sample that it tested, but even the ones that they tested and found to contain benzene, can we really trust their analytical methods? Can we really trust those results in light of FDA's findings?
Yeah, and Nilda, I want to appreciate keep us on track. PFAS, I believe is a big deal, and I'll let you tell me I'm wrong, but I think this is something worth making sure we focus on toward the end here.
Absolutely, and you are not wrong, Rob. PFAS could be its own 1-hour webinar, so we are just going to be covering the tip of the iceberg on PFAS here. But PFAS has been and continues to be a huge area of litigation in the cosmetics and personal care industry. PFAS stands for per and polyfluoroalkyl substances, and it actually, that term refers to a number of different things. So that's something to be aware of. I won't get into the science of it, but it's something to be mindful of because the specifics and the definitions matter for purposes of interpreting the data. PFAS can be present in cosmetics and personal care products for a number of reasons. It can be used intentionally, and it can also come into the product unintentionally. So here are a number of the I guess, attributes of PFAS that cause it to be in cosmetics, whether intentionally or unintentionally at times. So it can be used to extend wear, to make products more waterproof, essentially to repel water and grease. But it's also used in things like coating manufacturing equipment so that things don't stick to that equipment as they're being used in processing, or it can be used for cleaning products, or it can even be in the water supply. And so there are a number of different ways that PFAS can make its way into a product. Next slide. The states have been active and increasingly active in legislating around PFAS. We won't cover the specifics, but suffice it to say that these are a number of states that have waded into that pool, either passing legislation or considering legislation. On the class action front, products that can often find themselves as targets for PFAS litigation include products that contain labeling claims identifying them as natural, free of harsh chemicals, free of unnecessary additives, sustainable or clean. Plaintiffs are trying to sort of hang on to those terms, and then if they're able to identify PFAS in the products, they then say that the presence of PFAS is contrary to those labeling claims, and that the consumers wouldn't have purchased the product if they'd known that they contained PFAS. Let's move on to the next slide. One area that we may see developing, and this is deliberately following the PFAS slide because there's a link between the Modernization of Cosmetics Regulation Act of 2022 and PFAS. So this act, commonly referred to as MoCRA, was passed at the very end of last year, and will be taking mostly full effect at the end of this year. There's actually a provision in MoCRA that tasks FDA with studying the use of PFAS in cosmetics and personal care products. FDA under MoCRA is to issue a report on that by the end of 2025. And so there's room to argue under MoCRA that there's a primary jurisdiction defense that applies to PFAS claims, since this is something that FDA has specifically been tasked with studying and reporting on. This likely will not impact state litigation, or excuse me, state legislation on this issue, and that's because even though MoCRA precludes states and local governments from enacting requirements that are different from MoCRA's, it specifically allows states to prohibit the use of certain ingredients or to limit the amount of certain ingredients in cosmetic products under state law. And so therefore it is unlikely to impact PFAS legislation that the states are issuing. And then just at the bottom of this slide, there are a number of links to additional information on MoCRA, including that last link at the bottom contains some really valuable information on the draft guidances that were issued in 2023 relating to cosmetic facility registration and product listing under MoCRA. So definitely check those out to make sure you're staying abreast of what's going on with these new requirements.
Great, Nilda. We'll transition, thank you. Transition to mass arbitration. One just note, as you're defending or thinking about these cases where some contaminant is alleged to cause cancer or some other issue, there was a decision from the Ninth Circuit yesterday that I believe will be important in this area. The Ninth Circuit ruled yesterday that the California's Prop 65 requirement for Roundup or for glyphosate, allegedly causing cancer, violated the First Amendment because the statements that the state was purporting to require as part of the Prop 65 requirement or disclosures are controversial and thus illegal or unlawful compelled speech. I think that concept has a lot of usefulness in defending some of these other cases that we're going to have to develop. But turning to mass arbitration, Mike, why don't you sort of tell us what's going on here and how to give us a few minutes on how to prevent this.
Sure, I think we have just about 4 minutes left, so I'll try to make this summary. But essentially, mass arbitration occurs where you have a consumer or employment contract that has an arbitration provision in it, and that arbitration provision contains a class action waiver. So what has happened after decades and decades of companies successfully enforcing arbitration agreements with class action waivers is in about the last 4 years, the plaintiff's bar has started to try to flip that on its head. And so what they've done is they will go on social media or they'll go on the internet and they will aggregate hundreds, thousands, tens of thousands of individual claims with similar facts and the exact same legal theory. And they will file all of those claims together at once at an arbitration provider. But the cases are technically filed as distinct individual cases. And the rub for the companies is that under state law or under the arbitration provider rules, the company has to pay fees for each individual case that is filed. And so when you're dealing with thousands or tens of thousands of cases, just the fees that the company has to pay to get those cases in the door, not to arbitrate them to conclusion, but just to get them in the door can be astronomical. 10 million, 20 million. Some companies have received bills up to close to $100 million just to get these cases started. And so what companies are feeling is that mass arbitration is being used as a strategy to trigger these fee obligations and leverage them to force settlements for non-meritorious claims. You know, if a plaintiff's group will say, well, you could pay me $5 million just to go away, or you can pay an arbitration provider $50 million to get those just to get the cases in the door, it creates an incentive to file cases that may not have merit and may not win if they were actually ever arbitrated. And this has been a rapidly evolving landscape given the new legal theories and the new tactics that are emerged. And what I would say where the action is right now and has been over the last year for companies trying to combat mass arbitration is both to immediately modify their arbitration agreement terms to try to insert contractual provisions to protect them from these types of mass arbitration campaigns, as well as switching from some of the more traditional providers whose protocols, rules, and fee schedules maybe are not as conducive on the company side to a mass arbitration, and to switch to new providers who are coming out with protocols specifically targeting mass arbitration tactics. But all of these new provisions, these new providers, this is all being tested now, and the landscape is shifting. Sure, Rob.
No, Mike, I mean, just for a moment, I wanted to, we're sort of coming near the end, but I think this is important. So I encourage everybody to stick with us for a few more minutes to sort of cover. If anybody in the meantime has questions, please go ahead and put them in the chat bot. I'll make sure those questions get asked toward the end. But Mike, can you kind of pick up on the recent developments that you're seeing here in the mass arbitration context?
Sure. Just to touch on a couple of new things new providers that have emerged. Traditionally, American Arbitration Association and JAMS have been the most commonly used arbitration providers, but we're seeing new providers come out with new fee schedules and frameworks. One of those, for example, is National Arbitration and Mediation, or NAM, and they offer a 1 million initial filing fee cap, no matter how many claims are filed. And with the rest of those filing fees are then deferred. And that level of predictability and expense is something that companies have found attractive, given the initial filing fee bills that some companies have faced from mass arbitration. Another provider that's doing a couple things that are interesting is FedArb. And FedArb, companies need to pay an annual subscription fee to use FedArb's protocol. But once that subscription fee is paid, the filing fees per case are lower. And what FedArb offers is they use a multi-district litigation type panel, where there'll be a panel of arbitrators to decide all of the common issues in the case first. So in a situation where a company has a single defense that defeats all claims on a non-meritorious theory, the ability to use a common panel across common issues is something that is attractive. And even within, I think, the last month, FedArb has also modified its mass arbitration rules to provide that a company, even before they have to pay the arbitration filing fees, can bring an initial dispositive motion for things like failure to state a claim, failure to provide adequate specificity for claimants, failure to comply with contractual terms of the arbitration agreement, such as informal resolution. So this is something that's brand new that I've not seen any provider offer yet, which is that even before paying arbitration fees for a mass arbitration, the companies can have a chance to put the brakes on the mass arbitration and really challenge whether there's even a cognizable theory, whether the people asserting claims have even purchased the product, whether the arbitration contract has been complied with. And I suspect companies are going to find that option very attractive. Another trend that we're seeing a lot of companies do is actually writing certain protocols into the agreements themselves instead of relying on providers' protocols. And one of the most common things we're seeing is what we would call batching or sequencing, where companies say only so many claims can proceed at a time and the rest of the cases are stayed or are not filed. But for all of these new developments with new providers and new arbitration terms, they're being actively challenged in courts right now. And just a couple of very quick example of those, and how we're seeing, how this is there's so much uncertainty in the market right now with this, and in the case law, and how this is something that's going to continue to play out over the next few years, where companies are very closely monitoring this and looking to move quickly once some direction from courts comes out. But in a recent antitrust case involving a large ticket seller in California federal court, the company had tried to switch to one of these to a new provider's mass arbitration protocol. This particular provider was called New Era, and the court denied the company's motion to compel arbitration. The court found a lot of issues with what this company had done to switch providers from a traditional individual arbitration to a mass arbitration protocol. Procedurally, the court took issue with the fact that the change was made while litigation was pending, and then there wasn't sufficient notice to existing customers. But then substantively, the court raised concerns with the mass arbitration protocol, saying that it posed this, quote, serious risk of being fundamentally unfair to claimants, because it was unclear how, precedent or common decisions that were decided in the first instance, how those would be applied downstream to individual cases. And the court noted how there weren't certain procedural safeguards like you might find in multi-district litigation or class action litigation. But this court's decision is currently on appeal. It's being vigorously challenged, and it's a decision that we are actively watching, and it's pending in the Ninth Circuit. And we suspect the Ninth Circuit opinion, it may give very helpful guidance to both companies and providers who are looking to kind of see how far the envelope can be pushed, or what additional safeguards are going to be necessary in order to ensure these mass arbitration protocols are enforced. Rob, do you want me to go with another case, or?
Yeah, go with one more, and then maybe we can do some closing thoughts.
Sure. So another recent case, and this decision is also currently on appeal, but a large wireless provider tried to compel arbitration it was facing a mass arbitration, and it tried to compel arbitration of a class action that had preceded the mass arbitration using a new provision that it had written into its agreement. And that provision, in a nutshell, said if there's a mass arbitration, only 10 cases can be filed at a time. And all the rest of the cases have to wait for those first 10 cases. And then once those first 10 cases are resolved, if it's not settled, we'll go 10 at a time, 10 at a time until we're done. And the idea for the company behind that is if the cases aren't filed, then we don't get a bill for initial filing fees. And so we're going to limit this to 10 at a time. And the court refused to enforce that provision. The court took several issues with other issues in the case, but specific to this type of batching or sequencing provision, the court found that it was unreasonably favorable to the company to make consumers wait years to have their claims heard. The court also was concerned with that if consumers couldn't file their claims and there was not a tolling of the statute of limitations, which was not in the contract, the claims would effectively become time barred. In other words, that the effect of this provision was just to time bar claims by stalling them out. And so the court refused to enforce this provision. Again, the case is on appeal, and it's one that we're actively watching because, you know, if you look right now in the market, most companies are actively revisiting their arbitration terms and considering things like batching or sequencing procedures. And for companies that haven't started to revisit these issues, if you're using arbitration agreements for consumer terms, it's something you may wish to do immediately, and you'll want to pay attention to what these initial decisions have said when crafting your arbitration agreements.
Great, Mike. So just a heads up to everybody, I'm going to just to reiterate, if there are any questions, please enter them, but I'm going to come make one comment, and then I'm going to come, Rebecca, to you first, just for maybe a closing thought or two about what to expect next or what a key takeaway you might want people to think about. But just to put one footnote, so to speak, on Mike's presentation, is there is an increasing movement, effort to enforce standalone class action waivers in contracts, particularly with consumers. And to my surprise, at least, I don't know if I should say that, but it has gotten a decent amount of traction, meaning there's an increasing number of recent decisions where courts have enforced standalone class waivers outside the context of an arbitration provision. And I think those decisions can provide some drafting guidance as we continue to revisit these issues, meaning, again, think about including a standalone class waiver in addition to your arbitration agreement. With that, Mike, thank you. I think this is we're just going to continue seeing a lot of developments in this area. But Rebecca, coming to you first on privacy, what would you say for a takeaway?
I'd say takeaway, privacy suits are not going away. You may see less in the in case filings, but you're going to see them in mass arbitration, just like Mike just talked about. It's the right time to talk to your marketing team about what are they doing and get ahead of it.
Yep. So financial services, John, Sylvia, what's the takeaway? What should people be thinking about in 2024? What do you want them to get out of this this talk?
So as far as challenging class cert, really looking at the standing issues, as I mentioned earlier today, and certainly at the outset of a case, if you have a basis to challenge jurisdiction from an arbitrability standpoint, to do that. But as Mike mentioned, keep in mind the possibility of a mass arbitration flip.
Yeah, I'll echo that and be brief. I think, pay attention to the regulators, which I know a lot of financial institutions are doing, but particularly Coast, because as a lot of people mentioned, the class plaintiffs bar, follows on to those. And I think, just to echo what Mike McCarthy said, pay close attention to your agreements, because it's important. It's important for a lot of things that were covered today, for the arbitration issues, for authorization to record or disclosures, for the stuff Rebecca covered. it's always a good time of year to take stock of your agreements and make sure that they're up to speed with the latest and greatest to protect against mass arbitrations and these other types of claims as much as possible.
And Nilda, the cosmetics, personal care product space, what should people be thinking about?
So I think that a huge focus is going to continue to be on the science and, what does the science actually show? What do the data and the studies that plaintiffs are citing actually show? And how that can impact questions like standing, which will also continue to be a huge topic for class actions in this space. And finally, MoCRA. Making sure you're keeping an eye on MoCRA, staying abreast, and monitoring how it may impact class action litigation going forward.
Yep. And Mike, what should people be thinking about on mass arbitrations in 2024?
Sure. So courts generally across the board have been unsympathetic to company arguments that mass arbitration is unfair or too costly. And companies cannot be reactive to mass arbitration. If you're not out in front of thinking about this issue and addressing it before it happens, it can be a big problem. So for companies who have not already gone through this process or revetted their terms, we would highly encourage doing that immediately. And there will be some strategic decision companies have to make in terms of, do they want to keep arbitration? If so, which providers do they want to use? What rules do they want to use? How far do they want to push the envelope on enforceability? But it is just critically important to be addressing these issues on the front end, because once a mass arbitration is filed and you have these bills invoiced to you, it's too late.
Yeah, those are good. So with that, we will close and thank everybody for joining us. We hope this was helpful. The presentation materials, again, we tried to cover as much as we could, but there's a lot of additional information there, so we encourage everybody to look at it. If you have questions, please feel free to reach out to any or all of us as may be relevant. And I will happy Thanksgiving, and we'll head towards 2024 here. Thank you, everybody.